I'm Bill Pogash, the Director of the Pennsylvania Local Roads Program, LTAP. I wanted to take an opportunity to welcome you to the first of the new LTAP training videos. Training videos designed for municipal government, featuring municipal employees and highlighting policies and procedures affecting municipalities. I hope you enjoy the program and find it not only interesting, but helpful. Speaking for the entire LTAP organization, we welcome your comments on this topic or any of our other services. Drop us a line or simply call 1-800-4LTAP. Thank you.
Good afternoon, everyone. I'd like to welcome you to the Court of Common Pleas here in Wellington County, Pennsylvania. This afternoon we're going to demonstrate the various aspects of a tort case. It involves a contractor and it involves a township. The contractor and the township were sued due to a highway accident which occurred on the township roadway. The purpose this afternoon is to show you the various aspects of the case and how it proceeds from the time of the accident through the complaint, the discovery process, then ultimately to a courtroom proceedings with a jury decision. Let me introduce the participants this afternoon. Dr. Ronald Eck, who is a professor of civil engineering from West Virginia University in the T-Square Center there. Mr. Mike Blankenship is also with the T-Square Center at West Virginia University. Dr. John Anderson, who is with the Pennsylvania LTAP program and is our manager in Harrisburg. Mr. Ted Charlak, who is a senior deputy attorney general with the Commonwealth of Pennsylvania. Mr. John Capuzzi, who is also a deputy attorney general with the Commonwealth of Pennsylvania. And Mr. Richard Rosenthal, who is an attorney with the law firm of Edgar Snyder and Associates. I'm Walter Kilareski. I'm a professor of civil engineering at Penn State University and involved with our LTAP Center. This afternoon, Mr. Charlak will play the role of the judge of Wellington County of the Court of Common Pleas. Mr. Capuzzi will represent the defense in this case, while Mr. Rosenthal will represent the plaintiff in the case. Dr. Anderson, Dr. Eck, Mr. Blankenship, and myself will play the role of some witnesses. Let me tell you a little bit about the case. This case that we're going to use this afternoon was an actual case in the Pennsylvania system. It involved a township that is in Pennsylvania. If you look in your notebooks or if you looked at that, you'll see we've kind of blacked out names and locations to keep this anonymous. But this whole case has gone through the process from an accident all the way through a court proceeding in one of our county courts. The case involves Lincoln Township this afternoon. Lincoln Township is a rural township. They have about 28 miles of roadway in the township. In 1988, the township decided to overlay one of their pavements. It was one of the main roads in the township. The roadway passed the local school. In fact, the roadway passed in front of the township building. They received money from the Department of Community Affairs and also from PennDOT, and they worked with PennDOT Municipal Services to develop a contract for the paving. The roadway is a two-way facility, 2 lanes wide. The existing roadway is 18 feet wide. There were shoulders on both sides of the roadway. The shoulders consisted of soil and gravel, unstabilized material. And over time, the pavement was starting to deteriorate. The edges of the pavement were starting to break down. There were edge drop-offs in the shoulder area ranging anywhere from 0 inches to about 2.5 inches. The design called for a 22-foot wide roadway. And the agreement between the township and the contractor was that the township would prepare the shoulders for paving. In other words, they would stabilize the shoulders, get those up to the correct grade, widen them so that there would be a platform and a base for the contractor to pave 22 feet wide. The township was going to do that through the summer months. Well, they got all the way through the summer, and the township had not completed the work. They got into the early fall season. The contractor became concerned because as part of his contract there was a penalty clause in there that if he didn't get the paving done, he had to pay damages. The contractor contacted the township and met with a township supervisor on the project site to discuss this problem of not being able to pave because of the shoulders not being prepared. The contractor presented options. One of the options was to pave 18 feet wide over the existing cartway. The township supervisor agreed to that. The township supervisor said they would accept an 18-foot wide road. The contractor would pave a little bit farther because they were going to keep the material the same amount, so rather than a 1.25 miles of paving, they would get 1.5 miles out of the job. There were some letters exchanged between the township and the contractor, and I think you'll see the attorneys will present those as evidence this afternoon, which discussed the meeting that took place on the roadway and the agreement. Thursday and Friday of week in October, the contractor paved the facility, paved 18 feet wide. Friday afternoon, the contractor finished his job, cleaned up the job site, picked up all the work zone signs, and left the facility. That was Friday afternoon. Monday morning, approximately 6:25 in the morning, Mr. Wilson was traveling on this roadway. It was dry. There were no adverse conditions, but it was dark at the time, at 6:30 in the morning. There was a small dump truck in front of 2 other vehicles, a queue of 3 vehicles driving on the roadway. Mr. Wilson was the 4th vehicle. He decided to attempt to pass the 3 vehicles. Mr. Wilson attempted to pass the 3 vehicles on a downgrade. He got alongside of the small dump truck, and Mr. Wilson's vehicle left the left side of the roadway. He got back on the roadway in front of the dump truck, steered to the right, and got off of the roadway on the right-hand side of the pavement. Mr. Wilson's vehicle then left approximately 320 feet of yaw marks. The vehicle then impacted a utility pole and sheared off the utility pole. Mr. Wilson's vehicle then continued for about another 80 feet. It rolled over, and as a result of the injuries, Mr. Wilson died. Mr. Wilson's estate brought suit then against the township and the contractor for negligence. So with that, I'm going to turn it over to the Honorable Ted Shylock.
The whole point of this little exercise is to get you to be basically familiar with some of the basic courtroom procedures that you may encounter if you go into court. So these things, what you see here, should be in the back of your mind while you're doing your job every day, if only to avoid seeing someone with a black robe and having to deal with attorneys. I'm supposed to talk about what is tort liability and what is a tort. Well, a tort is a violation of a duty that's set by law. And I'll talk about how it's set by law in a minute, but it's a violation of duty that's set by law that leads to a lawsuit. And the lawsuit is to get money to compensate an individual for either personal injury, property loss, or some economic loss as a result of the breach of that duty. So it's not a contract. Some of you deal in the contract area. There the rights are dealt with and really set forth by the parties. These are duties that are set forth by the law. Just so that you know what some of the players here, you're going to hear the term plaintiff, you're going to hear the term defendant. The plaintiff is the person who brings the lawsuit, the person who's making the complaint, and that's the injured party or the allegedly injured party. The defendant is the person who is sued or the agency that is sued. Now, The person that is sued, sometimes individuals are sued in these kind of cases, and even the agent, but the agency will step in and really represent and take care of any monetary compensation that would have to be paid out. So the individual generally does not have to worry unless they're acting outside the scope of their employment. So if you're supposed to be inspecting a job on a Wednesday afternoon and you're out playing poker with your friends, and you have fifth of tequila or something like that, you may not be, the agency may not step in that regard. So you have to be acting in the scope of your employment. Some of the elements that make up a tort action, and there basically are four, and I want to just talk about those for a minute. I mentioned one, and that's duty. And there's really two ways that a duty can be set forth. One is a statutory duty, and that's a duty where in the law it says you have to build your shoulders 10 feet wide. Okay? That's kind of rare, at least in Pennsylvania it is. In fact, I just got an opinion that came down which said there are no statutes in Pennsylvania which say you have to provide a shoulder, you have to install guide rails, and you have to keep a berm. Statutes don't address that. What is addressed in Pennsylvania, and probably most of the other states, is there's a second way to get at a duty, and that's by common law. And that's where the courts come down and say there has to be some sort of standard which the agencies have to meet. So they set that standard. The courts do it as opposed to the legislature. And in Pennsylvania, the duty is you have to keep your roadways reasonably safe for ordinary travel. And keep that important, the aspect of being reasonably safe for ordinary travel. It'll come into play later on here today, and it also could come into play anytime you're doing any thoughts with respect to your jobs. Part of the duty is also notice, that there has to be some notice of the defect. It doesn't have to be an actual notice. In other words, you don't have to know that actually there was a drop-off or there was a missing sign or whatever. If you should have known through a reasonable inspection, that's enough to give you sufficient what's called constructive notice. So notice is a factor there too. The second thing after duty is a breach. In other words, there's a duty there to replace a stop sign. You didn't replace the stop sign, you blew it. So you've breached that duty. There's a third factor, however, and that is causation. And what that relates to is you can have a situation, let me give you an example. Say you have you're on a roadway and you have an overpass going overhead and it's a low clearance. Well, say a clearance of, say, 12 feet or something, or 13 feet or something like that. And when you go out, you put your sign up and it says 7 feet. Well, say there's a car that happens to go under that, passes through it, and then gets involved in an accident on the other side. You were negligent for putting up the 7-foot clearance sign, but it had nothing to do with that accident. So you may have a duty there to put up the sign. You may have breached that duty by not putting up the right sign, but it had no effect whatsoever on this accident. It had no cause. So that would be enough to get you out of the case with respect to that. So it didn't reach that third factor. The fourth factor is damages. There has to be some sort of injury. You have a situation where you could have had a duty, blown the duty, it could have been directly related. There could be cause there, but if the person's not injured or there's no economic loss, then there's no cause of action and you can't proceed. So those are the four basic elements of what is involved in a tort action. And if all four are found, you can be found liable. So that's the tort aspect. What does liability mean? Well, liability means that you're held accountable. You're responsible for any lack of care that results in an injury or lack of care where a person in a similar situation would have acted otherwise. What to do? I mean, what do you do in these kind of situations? Note that throughout I've mentioned the term reasonable. If you act with reasonable care, you have some reason or some common sense in what you're doing, you should be in pretty good shape. And again, you don't have to make the roadways absolutely totally safe. They just have to be reasonably safe. So if you leave here today with just one word in your mind, it's reasonable. Reasonable, common sense approach, which should be enough. How do you go about doing that? Well, there's a couple of ways. One is to do inspections. That's one way to do it. Another is to try to anticipate or predict what a common ordinary traveler should expect on a roadway. That's another thing that you should keep in mind. The third is to follow your manuals, your procedures, your guidelines. That's something that your organization has already set. So if you deviate from that, there can be a problem. The fourth thing is if you happen to deviate, then what you want to do is you want to have a good reason for doing it, and you want to document it. You want to have something written down to show what you did and why you did it, because time plays a factor here. because a suit will not come down right away, and it may come down years later. And after that, by the time you're called in, maybe years after that. So it's important there's some sort of documentation with respect to what you've done. Another thing to do is to respond to complaints. If you get complaints from citizens or legislators or whatever, respond to the complaints to show that you have that kind of ability to go out and address their concerns. And the last thing is to maintain your files. It ties in with a factor I just mentioned, that it's going to be a couple of years before you get to the point of where the action may be brought. So if you have a good file system, you're able to go back, access that, and present a pretty good defense. The other thing I was supposed to talk about is the complaint. And really what I'll talk about here a little bit broader is just the pleading process. Because the complaint is the first pleading in an action. And a pleading is simply a plea. And a complaint is basically what you would think commonsensically it is. It's an allegation or a complaint. It's saying, this is what we think you did wrong, and we're putting on you on notice with respect to that. Now again, one of the things here is that complaint most often doesn't come down for about 2 years. So you may have the accident occurring, and 2 years later you get the complaint alleging what they say you had done wrong. So there's a big time period there, and oftentimes you don't have sufficient notice to be able to work up and prepare for what's going on or what will go on later on. One thing to remember, and again, another thing, if you can leave here and remember this, it would be appreciated by the attorneys who represent you. If you do happen to get a complaint, either as an individual or through your organizational capacity, make sure you get it to a supervisor or get it to your attorney, because you've got to get on very quick. There's a limited time period for when you could go and respond to that. And that's the other aspect of the pleading process that I wanted to talk about. There are at least 5 other pleadings that you may be involved in, and I want to talk about that for just a minute, and then I'll end and we'll pass along to the next stage. The pleading that would follow the complaint, again, the complaint is just the complaints that they have with respect to what they say you had done wrong, would be the answer. And that's commonsensically, it's the answer. You're going to respond to what they say. And again, the attorney may need some input from you with respect to what to put into that answer and how to file it. Let me give you an example. You may have, say we have a situation where there's an obscured stop sign as a result of foliage, and the sign is missed, and the car goes on and hits some guide rail, smashes into some rail, and an injury occurs. Your answer with respect to that is, you may come back and you can say, no, the sign was not obscured. My records indicate I was out there the day before. I specifically looked at that, and it was not obscured. So you'd have an answer there. You'd also be a great witness or client for us. That's rare when something like that would occur. But that would be an example of an answer. Also included with that, and a pleading as well, is what's called new matter. And with new matter, you set forth your defenses. And again, you help the attorney in crafting your defenses in this regard. For instance, a defense here could be, well, it was obscured, but there was at least 700 feet prior to that stop sign where somebody had a clear view of it. And in fact, it was a double stop sign. We had one on both sides of the road, and the other one was not obscured. So that's a way to present a defense in your new matter. Also, part of that, too, is you can make a counterclaim. You know, I said the guy cracked into the guide rail, and say you messed up the guide rail. You can put in there a counterclaim for the repair of the guide rail. If you haven't already done, if the department hadn't already done that, to pay the contractor to repair that. The third type of pleading, aside from the complaint, is a cross-claim. And there, a cross-claim is if there's other defendants involved in the action. So, and what often happens is you have a shotgun approach where the plaintiff will sue a number of parties. So say in this case that I've talked about, they sued the property owner where the foliage was coming out of. Say it wasn't your property, but say it was a property or private property. And they were brought in as well as original defendant. Well, you can make a cross-claim against them saying, well, look, it was on their property, we've notified them before with respect to this, and you can establish your cross-claim there. The fourth type of pleading is what's called a joinder complaint. And a joinder complaint could be where, using this example, say we have a contractor who is in charge of foliage removal, and we're supposed to have been out at that time period removing the foliage, spraying and cutting back, and it didn't happen. We could bring a separate action against that individual, say, or that company or whatever, as an additional defendant to come in and be responsible for that. And the last one is mostly a legal type of pleading. It's called your preliminary objections. And again, mostly you probably won't have a lot of input on this with respect to your attorneys, but it's a matter of the attorney coming and saying, in essence, okay, say all of that's true, so what? We have immunity. Maybe the legislature had given immunity for this type of situation. So that is basically what you have for your pleadings. And the complaint is basically what had been outlined earlier by Dr. Kilareski. I'm going to talk about some of the things by way of a stipulations that are agreed upon with respect to this case. But I'm done for now. What I'm going to do is hand it over to the attorneys who are going to talk about the next stage that follows the pleading stage, which is the discovery phase.
First thing you have to do is notify your solicitor. And you just can't have your solicitor say, send it to me. Worst thing that can happen, you've already lost 3 days. You got it. You have 20 days from the day you get it in which to file that answer. 3 days to send it down. The solicitor's got to get back to you. Before you know it, you might be 30, 40, 60 days before any action is taken. Mr. Shilak talked about preliminary objections. Same thing. You have to file those preliminary objections within 20 days. If you fail to meet that deadline, you may have waived some of the legal defenses or some of the legal arguments that you had at that point in time. So it's imperative that everyone have a heightened awareness of how important time is. Time is of the essence in lawsuits. The courts don't take kindly to missing deadlines. Even though there's a rule that says liberal construction, there are certain things where they won't be liberally construed, and pleadings is one of them. Once the lawsuit is initiated, how do you get to where you want to go? You go from the pleadings to the trial. Some of the things that I look for is to ascertain the facts that are relevant to the case. You get a pleading in, you get that complaint in. It says, you did this, you did that. Everybody knows it's not 100% true, no matter what's said there. Before you can take the second step, you have to gather the facts. For you, as a municipal official, you've got to look at that complaint and it says, okay, there was an accident on such and such a road on this date. Do you have a local police force? You want to start with the police accident report. Was there a police accident report? If not, did the state, from the locals, does the state police handle that area? You want to start to build the basis of where this suit's going to go. Your attorney's going to need this because you're going to start to frame the issues. We want to test the competency of the witnesses. In the case today, you'll see that there were witnesses that were behind Mr. Wilson's vehicle, witnesses in the other vehicles that he passed. You want to be able to test what they observed. Did they really see it? There could be two people in a vehicle. Car passes them on the left. Heck, they might have been talking to each other. Neither one of them even saw what happened. They hear the crash, and all of a sudden they reconstruct in their mind what they think happened. Neither one of them really saw it. So you want to test the competency of the witnesses. Gauge the demeanor of the parties and the witnesses. Very important as a trial attorney. I don't like to go to trial without having some idea what the witness looks like, what the party looks like, how they're going to react, and so forth. We want to narrow the issues. The pleading comes in, the complaint comes in, guy's claiming this huge economic loss. We started in the discovery process. What do we find out? We find out the guy's an independent, wealthy millionaire that has people that just manage his stock portfolio. He hasn't lost one penny. In fact, the market went up, and the guy's made money at that time. where he's claiming this economic loss. In reality, it's not there. So we narrowed one issue. We want to frame the legal analysis. Maybe a lot of things they complain about. They may complain about the drop-off, the lack of signing, and so forth. We have to know where they're coming from so that we can cut out parts of that complaint. Narrow it down. Let's focus the issues. Did we have notice of that? First thing you have to start off with. Did you have notice? Did anybody complain to you? Did you do any inspections? So we want to develop where our legal analysis is going to go. And that's based partly on the facts. You just don't make up your legal theories because you have to have facts that support them. You can't say to the judge, well, Judge, we shouldn't be in this case because we didn't do anything wrong. You've got to show something substantive to back that claim up. Obtain the documents that are pertinent. In every case, there's always something that's asked for. And it doesn't have to be just a document. It could be something else. It could be in a case that you need to inspect the vehicle. It's one of the ways of doing it. In this case, we have a letter. In fact, we have two letters in this case that are very important, obtained through discovery. They're very relevant to the case, and in fact, from Rick's perspective, it's the smoking gun. You want to learn the identity of the expert witnesses. In this day and age, most of the cases that we handle, most of the cases that you'll be involved in, have some type of expert witness. Maybe an expert witness that does the liability side, such as Dr. Eck or Dr. Kilareski, or it may be a medical expert that's testifying as to the injuries that the person sustained. Discovery is also to prepare your client. As you're going to see today, poor Mr. Gates is going to go in there and he's going to be humbled, and there's not much he's going to be able to do about it because we have this letter from the township and so forth. But the thing is, I don't want to find out about this letter from another party, in this case the contractor, before I find out about it from my own client. Impeachment. From both parties' perspective, we look for documents to impeach the other side, to impugn the credibility of the witnesses. In this case, we have the letter. Now, if the township were to get up and say, oh, we never received any letter. Well, wait a minute, we got this from the contractor, and we also have a letter that you sent. Why did you send that letter if you didn't receive the first document? It just doesn't make sense. But that's the type of things we're looking for. People have a tendency, all of us, to want to protect ourselves. We know that we probably screwed up. It's probably going to look bad. Maybe we can hide it and nobody will find out. Sometimes it happens. More often than not, it doesn't. So you have to be upfront with your attorney, give him the good, and also give him the bad. As I tell my clients, don't ever lie. It's much easier for me to deal with the truth than it is to try and rehabilitate you after you've made a misstatement on the witness stand or at deposition. Once the facts are out there, we can deal with the facts. I can't deal with the unknown at trial as easily as I can when they walk up with the smoking gun.
As you all are aware, there are two sides to every story. And you've heard a defense perspective as to how you protect or take care of the interest of the defendant. Because clearly, most of you represent municipalities or are with construction companies or with a governmental entity. An attorney such as myself who does plaintiff's personal injury work is not going to accept a case against a governmental entity for the fun of it. Because making a claim against a governmental entity or against a contractor is not a red car, blue car, stop sign accident. It's a very difficult case, and it's a complicated case. Because any time you're using engineering testimony to justify your recovery, you're outside of the field of the judge saying, when car A rear-ended car B and the operator went through the windshield and his injuries were caused from the impact, clearly there's a breach of a legal duty and he's entitled to damages. What you get into in cases involving roadway defects are areas that to some extent are gray. As Mr. Shylock told you originally, there is no absolute duty under the law to provide a berm, meaning there's no statute that says you must provide a berm. But the leading case in Pennsylvania, where I practice law, says you have a duty to provide a reasonably safe roadway. And if in a case such as we have here, a township supervisor who unfortunately from his perspective is not trained to be a roadway supervisor, he's a plumber by trade, is put in the situation where he has to make a decision that involves, in this case, life or death, he's faced with a very precarious situation. Here's a gentleman who is made a township supervisor. Maybe he runs for the position, maybe he serves an unexpired term of somebody who was elected. But nonetheless, he's a township supervisor. The other two township supervisors are busy, and a contractor calls him out to an accident scene, what later becomes an accident scene, out to a roadway that's the same roadway where the borough building may be located, and says, look, I don't think a 22-foot roadway that is in the contract that PennDOT did the specs for is what we can do here. I think we have to reduce it to 18 feet. Now, this gentleman is trying to do his job, but he's in charge of the police department relative to the way the superintendent or the supervisor positions are in a municipality. And so what I'm trying to say to you is, in many instances, people who work for a given entity do not have the requisite knowledge or experience to make certain decisions. And rather than make a decision that can have life or death consequences, many times reasonableness, and that's the term that you heard from Mr. Shylock, who's the judge here, reasonableness dictates you don't make a decision where you don't have the knowledge, especially where somebody can be seriously injured. Now, as I said earlier, a plaintiff's attorney, and I've done defense work and I've done plaintiff's work, does not take a case against a governmental entity because they're going through an exercise. Somebody better be injured because the amount of time and effort that will be put in by all parties, the defense, the plaintiff, the engineering experts, is very, very substantial. In a case such as we have here, township supervisor unfortunately is called out. This is the letter from the township supervisor. It's dated after the initial letter from the paving company. And it says, this letter is to confirm receipt of your letter dated October 11th, 1988, regarding meeting with Mr. Blank and Mr. Blank to pave the above referenced project. After inspecting road conditions, it was determined that due to the incomplete and lack of I-do-2 paving on edges of the roadway, it was decided to pave at a width of 18 feet as opposed to 22 feet. Now, this document would come up in discovery. I'm the individual who's sending interrogatories, which are questions under oath, and requests for production of documents, which are also documents that you as people working for a township or answering the interrogatories would have to answer. Now, I'm going to bring Dr. Eck and Dr. Kilarowski forward because they're going to explain to you what they do as a reconstruction expert and the importance of that in the overall litigation proceeding. Thank you very much.
One key factor that enters into the testimony of experts is that experts have the legal privilege of expressing an opinion. You'll see actually two types of witnesses here this afternoon. There'll be two what we would call fact witnesses that can testify to what they did or what they saw or what they heard. But there'll also be two engineering expert witnesses, and you'll notice they will be able to testify or give opinions about certain issues. So that's the key difference. With that privilege also comes, I guess you call it a burden or a duty, and that is that the experts have a burden or duty of making sure, or an obligation, to make sure that they are objective. In many cases, the expert's opinion will be documented in a report, and in other cases, the expert's opinion may be discovered through deposition. For example, in Pennsylvania, it's pretty much standard practice that the experts will prepare a report. On the other hand, in my home state of West Virginia, it's just the opposite. In those cases, the experts usually give depositions as opposed to prepare written reports. The general rule for an expert is not to prepare any written report
unless or until you're actually instructed to do so by the attorney that you're working with. And I think you can appreciate why, that if something came out that was adverse to your side, that having that in writing could be very, very detrimental. The report needs to be a carefully prepared, carefully thought out document. There probably should be an introduction and background to the case, a brief description of the accident or the incident that you're talking about. If it's a highway defect case, there should be a discussion of the standard of care or the standard of practice relative to that area of the highway or the roadway. Then there should be assessment of how the roadway or highway section may have deviated from the standard, if that's the case. And if talking as the point I'll be taking today, which would be the plaintiff's side, the plaintiff's expert would of course be trying to point out these defects or these problems with the roadway. And then the report should also attempt to show how the defect related to or was causative to the accident itself. And there's been some discussion about that also here this afternoon. And then finally, the expert's conclusions should be clearly stated. As I think you can appreciate, and as will become clear today, the expert's report is a very important document. It allows the other side to see the opinions and the basis of those opinions of the expert, so that the other side can then have a feel for the strengths and also the weaknesses or the drawbacks of the expert's opinion. The report may also serve as a negotiating instrument for the attorney in the case of settlement talks. While the expert wants to probably elaborate as much as possible on what he or she has found, the more you elaborate, the more you open yourself up to counterattacks from the other experts or from other attorneys. So the actual report will probably be a compromise between minimal disclosure and full disclosure of what the point you're trying to make. The opinions should be stated clearly, and also the basis for those opinions. And it's important to give the basis for your opinions. The report should be written in what I would call very tight wording or tight sentences. You don't want anything to be misconstrued, or you don't want anything to be unclear. Flat statements or general statements, such as in general engineers feel, that is not an appropriate, in my opinion, not an appropriate statement to put in an expert report, because unless you've actually surveyed engineers in general, there's really no way you can back up that statement. I think it helps to add graphs, charts, photographs, and things like that to the report to help support your points. It's important that you and the attorney, if the case is going to go to trial, that you and the attorney sit down and discuss each and every sentence of the report in detail, because the attorney has to understand it just as well as you do. And to repeat also, the expert must be able to stand behind each and every statement or claim that is made in that report. So I think at that point I'll stop and turn it over to Walt to add any of his thoughts or comments. Walt?
Thank you, Ron. Just a few other thoughts on an expert witness. Experts will have difference of opinion because of engineering facts. For example, Dr. Eck may use 0.5 for the coefficient of friction, and I may use 0.75. We're both right. We may both be wrong. But in the realm of reasonable engineering certainty, 0.5 and 0.7 are quite acceptable as a coefficient of friction for the pavement. So we can differ professionally. As Dr. Eck said, at the end we have to render an opinion and conclusions and have to stand by those opinions and conclusions when we get onto the stand. With getting onto the stand, I'm going to stop here. What we're going to do now is take a little break, give you a chance to get some refreshments. When we get back, we're going to get onto the stand. The supervisor will be questioned and examined. The contractor will be questioned and examined. And the experts will be questioned and examined. So it'll give you a chance to get a feel for this case, and then you will help make a decision as to who was negligent and what the liability was. So let's take a break, be back in about 25 minutes, and we'll resume the case.